The Sixth Amendment to the United States Constitution guarantees crucial procedural rights to individuals facing criminal prosecution. We will examine the full text now. It states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." For the purposes of this module, we focus intensely on two core components. First, the right to counsel, which ensures representation throughout the proceedings. Second, the Confrontation Clause, which governs the reliability of witness testimony presented by the prosecution. Understanding these fundamental trial rights is absolutely essential for success on the uniform bar examination, as they form the bedrock of the American adversarial justice system. We must now transition from the text of the Sixth Amendment to its practical application, particularly regarding the right to counsel. Initially, the Bill of Rights applied only to the federal government. The critical step for criminal defendants nationwide was the incorporation of this right against the states through the 14th Amendment's Due Process Clause. This incorporation process was gradual, but the right to counsel eventually became recognized as fundamental. The baseline rule established is that the right to counsel attaches at all critical stages of the prosecution where the defendant's substantial rights may be affected, such as arraignment or trial. Before landmark rulings solidified this scope, the interpretation was much narrower, often limiting counsel only to capital cases or where the defendant could show special circumstances. We will explore how these landmark cases transformed this right into a universal guarantee essential for a fair trial. The right to counsel, now firmly established as fundamental, reached its zenith in the landmark 1963 decision, Gideon v. Wainwright. The facts involved Clarence Earl Gideon, an indigent man charged in Florida state court with a felony, breaking and entering with intent to commit a misdemeanor. Gideon requested the trial judge appoint him an attorney, but the judge refused, citing Florida law which only provided counsel in capital cases. Gideon represented himself, was convicted, and subsequently appealed. The Supreme Court unanimously held that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial, and thus, the states are required to provide counsel to indigent defendants charged with a felony. This was a massive expansion. Crucially, the modern application has broadened this rule beyond just felonies. Today, the requirement to appoint counsel applies whenever a defendant faces the possibility of actual imprisonment, regardless of whether the charge is a felony or a serious misdemeanor. Having established the right to appointed counsel, the next logical question arises: what if the appointed lawyer performs poorly? The mere presence of an attorney is insufficient if that attorney fails to provide competent representation. This crucial issue was addressed by the Supreme Court in the 1984 case, Strickland v. Washington. Strickland established the controlling standard for evaluating claims of ineffective assistance of counsel. To succeed on such a claim, the defendant must satisfy a rigorous two-pronged test. First, the performance prong requires showing that counsel's representation fell below an objective standard of reasonableness. This is judged by the prevailing professional norms, meaning the lawyer made errors that no reasonably diligent attorney would have made. Second, the prejudice prong requires demonstrating that the deficient performance actually prejudiced the defense. Prejudice means there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Both prongs must be satisfied to overturn a conviction based on ineffective assistance. We have covered the right to have counsel, and the standard for ensuring that counsel is effective under Strickland. Now, we bridge this crucial protection to another fundamental Sixth Amendment guarantee, the Confrontation Clause. While effective counsel defends the accused, the Confrontation Clause serves a complementary purpose. It ensures the reliability and trustworthiness of the evidence presented against the accused. It is the mechanism by which the defense tests the prosecution's case. The text of this clause is explicit. It states, "In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him." This right is not merely about having a lawyer present. It is about the defendant's direct ability, through counsel, to challenge the source of the incriminating testimony. This sets the stage for understanding how the Supreme Court interprets this vital right to confrontation moving forward. The primary mechanism through which the Sixth Amendment guarantees confrontation is the fundamental right to cross-examine adverse witnesses at trial. This is not merely a procedural formality. It is the bedrock of adversarial testing designed to uncover the truth. Historically, the framers were deeply concerned about the Crown relying on written accusations or affidavits, statements made outside of court, often without the defendant present. This practice, known as using ex parte evidence, allowed the prosecution to present damaging testimony without ever subjecting the declarant to the crucible of cross-examination. The Confrontation Clause exists precisely to prevent this historical evil. It ensures that the jury can observe the witness's demeanor, and that the defense has the opportunity to probe the truthfulness and accuracy of their statements under oath. Without this direct testing mechanism, the reliability of the evidence presented against the accused is severely compromised, undermining the fairness of the entire proceeding. The right to confront witnesses only applies to statements that the Confrontation Clause is designed to regulate. Following the landmark decision in Crawford v. Washington, the Supreme Court established a critical, bright-line distinction, whether the statement is testimonial or non-testimonial. This classification dictates whether the statement is barred unless the declarant is unavailable and was previously cross-examined. Testimonial statements are those made under circumstances that would lead an objective witness reasonably to believe that the statement's ultimate purpose is to establish or prove past events, potentially relevant to later criminal prosecution. Think of formal statements given to police regarding what happened yesterday. Conversely, non-testimonial statements are those made primarily for purposes other than establishing or proving past events. The classic example of a non-testimonial statement involves statements made to police during an ongoing emergency, where the declarant's primary purpose is to enable police assistance to meet that immediate need, not to create evidence for trial. Understanding this testimonial versus non-testimonial dichotomy is absolutely essential for analyzing Confrontation Clause claims. Now we apply the core holding derived from the Crawford decision. Remember, the Confrontation Clause only restricts testimonial statements. For a testimonial statement to be admitted against the defendant without the declarant testifying live at trial, two conditions must be met simultaneously. First, the prosecution must demonstrate that the witness is unavailable to testify. Second, the defendant must have had a prior opportunity to cross-examine that witness, typically during a preliminary hearing or a prior proceeding. If both conditions are satisfied, the testimonial statement is admissible. However, if the statement is deemed non-testimonial, the Crawford rule does not apply, and the statement is generally admissible regardless of the witness's availability or prior cross-examination opportunity. This brings us back to the crucial exception we mentioned: statements made to enable police assistance to meet an ongoing emergency. Because the primary purpose of these statements is immediate safety, not evidence gathering, they are classified as non-testimonial and are therefore admissible even if the declarant is unavailable and was never cross-examined. We have now covered the essential components of the Sixth Amendment's guarantees for the accused. For your uniform bar examination preparation, remember these three critical pillars. First, Gideon v. Wainwright mandates that the state must provide counsel to any indigent defendant facing actual imprisonment, even for certain misdemeanors. Second, Strickland v. Washington established the standard for competence. Counsel must perform reasonably, and any deficiency must have prejudiced the outcome. Third, regarding evidence reliability, the Confrontation Clause, interpreted through Crawford, strictly limits the admission of testimonial statements unless the declarant is available for cross-examination. These interconnected rights, the right to counsel, the right to effective counsel, and the right to confront adverse witnesses, are the bedrock ensuring that every criminal prosecution in this nation remains fundamentally fair and adversarial.